All set? There we go. Good afternoon, everyone. Welcome to yet another one of our informational virtual seminars by the Fishtown District. For those who don't know, I'm Mark Colazzo, Executive Director of the Fishtown Kensington area BID. My much more talented colleague is also on the call, Kay Anderson, who is our Director of Operations. Hi, Kay. And today we wanted to use the opportunity of litigation that we are using to help redevelop a property that had been sitting dormant in our corridor, to educate everybody regarding a legislative tool that is certainly very personal and near and dear to my heart, and that is the Conservatorship Act, or Act 135. And the basic purpose of that, and we'll kind of get into a little bit of the history today as well as introduce our presenters, is we've all dealt with this no matter what neighborhood you're in. There is always that one vacant, blighted property on a block that has causes the neighbors problems, whether it's because it's falling down, it's becoming unstable. It is an eyesore. It has become a location of crime or a danger to neighborhood residents or children. And Elle and I, with certainly the good work that they do, there's only so much that the city of Philadelphia can do to take this vacant, blighted eyesore and return it to productive use, to actually get it back, not just rejuvenated as far as appearance and use, to get a family or get it occupied, and also get it back on the tax rolls, get continuing revenue brought back in. For those that kind of do this already, know that with the city of Philadelphia, Elle and I can issue violations, and at some point they can, what we call abate a property, which would be to secure it on the lower level. If taxes go uncollected, they can move for a sheriff's sale. But none of that guarantees that the next owner is going to do anything different. So back in my former life, before I was doing this type of work, I was the Chief of Staff for State Representative John Taylor in the 177th Legislative District. And in dealing with all of these problems, we wanted to create legislation that can help us achieve what we're doing and incentivize community groups, neighborhood groups like the BID, like civic organizations, like private developers, a way to take power for themselves and be the part of the change they want to see in the neighborhood. And we, along with some of the people I'm about to introduce you to, worked very hard, many years, to bring this legislation over the finish line. And it's important to note as we go through this, this is not eminent domain. We are not going in to take somebody's property who is properly maintaining it or properly listing it for sale, or more importantly, occupied. These are for those properties, whether the owner died, whether the owner's just been sitting on it forever, and is doing nothing other than bringing down the collective values of the neighborhood. And after initiating this process, after we finally passed the legislation, the next step came with, now we've got to get people to utilize it and get people to know about it, because as I'm sure some of you already may not have heard of it or not really know about how to bring it to action. So I was in charge of that for Representative Taylor, and during that time, I realized that my old legal colleague, I won't say old because I'm probably older than he is, Richard Vanderslice, was very involved in doing these things. And I got to meet possibly the nicest gentleman that I've ever met, ever. His name is Joel Palmer. And Joel and his old partner formed a nonprofit, a 501, I believe, C3, called Scioli Turco. We'll have Joel talk a little bit about that in a minute. And their sole purpose was to do conservatorships. That was it. It was to help redevelop neighborhoods, which was what a great purpose. And then this year, or actually last year, one of my dear friends who we were actually CITs together in camp. Beth Grossman, many of you know Beth from her days in the DA's office doing great work. Well, now she's executive director for this organization and for a wonderful nonprofit called Caring People's Alliance. We worked together back in 2014 to amend the act, House Bill 1363, to help bring practical changes. Because after we brought it, we wanted to see how it was working. How can we make it easier and really protect everyone involved in order to make sure this act was moving. Before I turn it over to Rick, I want to introduce Mr. Palmer, kind of talk a little bit about what drew him to the act and to create Sholi Turco. And then I want to have Beth say a few words before we get to Mr. Vanderslice to kind of take you through our presentation today. Joel, it's all you.
Thank you very much, Mark, and thank you very much for the kind words. I appreciate it. Sholi Turco was formed, as many organizations like this are, because of a need in our own neighborhood. We had a derelict Veterans of Foreign Wars building down on South 8th Street that had been a former gang haunt and had fallen into very bad disrepair. And we felt that it was a nice neighborhood and something we could do. So I did a little bit of research and was introduced to Rick, who knew about Act 135. I did not, and said this would be a good conservatorship property. And we did file the conservatorship, and it was ultimately successful. The name Sholi Turco derives from that Veterans of Foreign Wars chapter 593, named for two World War I vets, Sholi and Turco. And so we called the Secretary of State and said, no, the name has lapsed, over the many years, you can have it. So we paid the fee, and that's how we got the name. But since 2011, working with Rick and now with two other law firms and under the aegis of Beth's organization, Caring People Alliance, we have filed more than 125 cases, all but a couple of them successfully. And that's how Sholi Turco came to be. So I'll turn it back to Mark.
Thank you, Joel. And just so you know, in my days with Representative Taylor, and then before I was fortunate enough to be able to come work for the Fishtown bid, I ran the Mayfair Business Improvement District 3 years. So of all those 125 cases, I know several of them were ones that we worked on together, both in the River Wards and in Mayfair. And we joked with some of them. I remember there was one in Mayfair on Sheffield Street, and it was right on the corner.
Yep.
And what the owner did was basically board up the windows and paint drapes on them. So if you just drove by, it looked like it was drapes, but the house was falling apart. And he thought ultimately that he could avoid having to do anything. And we ultimately were able to move on it, fix it up, get control of it, fix it up. And now a family has been living in it for several years. So it's, well, as you'll see today, it's part of the great work. I want to introduce Beth Grossman, or reintroduce her to some of you. Beth's done a lot of work on properties and fighting blight over the years, and we're so thrilled that now she's involved with Sholi Turco and Caring People's Alliance. So Beth, I want to turn it over to you for a few minutes.
Just briefly, thank you very much, Mark, for you and Representative Taylor for getting this wonderful tool up and running. And to Joe, I know that Sholi Turco is your baby, and Rick, you're a wonderful counsel. I'm just happy to be here to let you all know that we are here as a resource. Act 135 is an incredible tool. And just so you know, it's not that we are taking ownership rights away from a property, it's just giving us control over it. I don't have to tell all of you, how problematic, one property on a block can be, because it could really drag down the whole block. And I have experience using different tools over the years, closing down drug properties and nuisance bars. And I was chief of staff for a year at LNI. Sorry, one person can't fix it, but I tried. So I know a lot about properties, code enforcement, and things of that nature. And as I'm sure Mark knows, so much to do, but I have other experience. I'm always happy to use my knowledge of dealing with properties and solutions. But we are here. Sholi Turco is here for you. And I hope we can just continue to make your area of the city better and better.
Thank you, Beth. And before I turn it over to Rick to take us through the nuts and bolts of the act and the litigation process, what formulated us to bring this to you today, besides just as an educational tool and a resource tool, was that we filed with Shirley Turco and Mr. Vanderslice a conservatorship action, when I say we, meaning the Fishtown bid, for the vacant property of 401-05 East Girard Avenue. Many of you are already familiar with that. That was the old, I guess, Mission building. It's a wonderful big property, has been sitting vacant forever. Since I've been here in this job in January, constantly right next door is DePinto Guitars, and I'm constantly having to help them from leaks in the property, coming through into their property, causing flooding, trash being dumped, people breaking in, stealing, sometimes squatting. And our goal with this is, and there's no ownership interest anymore. That nonprofit that ran it is no longer in existence. So there's sort of sits in this limbo other than the jewel of Act 135, where we are now going to be coming in the process, the petition was just filed, that so that we can turn this property into a wonderful mixed-use building with residential, a commercial unit downstairs, and I've also talked, besides with our executive staff, I know Casey O'Donnell from Impact is on the call. We want to talk about ways to create something in there to help our neighborhood, whether it's a job incubator, job creation tool. So we're working through that now. That's something we're going to be coming to the neighborhood and discussing. But the goal is to really bring this property and really that part of the corridor to life. And as you're going to see, it's not just getting control and ultimately getting ownership. It's also about clearing up many liens that have been placed on this property, getting taxes paid, and getting a continuous source of revenue. So now property values increase. A damaged property causing problems is gone. Blight is removed. An eyesore is removed. And all of a sudden, that corridor is now reactivated. So at the end of our presentation, we're happy to take some questions. We ask you to hold off until then. But last but not least, I want to turn it over to F. Lee Vanderslice. Rick, it's all yours. Kay, if you could share your screen to Rick so he can run through the presentation, that would be great.
Rick, you can either share your screen and go through it yourself, or I can share mine and flip through for you, whichever you prefer.
Let's see if I can get this PowerPoint up and then go from there. So can everybody see the first slide? It has Mark's name on it, Shirley Turco, and
Yes.
okay. So a quick overview of the act, as Mark said. It's a tool that came along a little over 12 years ago that will allow nonprofits, near neighbors, RCOs, and municipals to apply to the court to become like a receiver or a trustee of a property, to repair it and return it to productive use. What that means is it is a court process. And as any attorney will tell you, litigation is never certain, but we try and review these cases before they're even filed to make sure that it's something that at least we have the confidence that we can bring a case that should be successful. As you'll see in a few minutes, there's several twists and turns that they can take, but in general, there are a few
Obstacles?
Yes, it's been a long day. So there are four obstacles which will bar a conservancy, or an application for a conservancy will get knocked out right off the bat. The first is, I believe it was mentioned, if a property is occupied legally, meaning the person is not a squatter or has some equitable interest, usually an heir that's living in the property, that is something that is totally off the table. If the person is there legally, meaning they don't fit the definition of a squatter, which has been further defined by Philadelphia recently. And for those of you who haven't heard, a quick aside, there is a new squatters law for Philadelphia that allows for people who are less sophisticated squatters to be taken out of properties. We've used it in a couple of these cases so far, and to varying degrees of success. As most of you know, removing squatters from a property is never easy. So as long as it's not legally occupied, if the owner is not listed it for sale in the past 60 days, and listing it for sale could be anything from putting it on the MLS or LoopNet, a commercial listing, putting it on Craigslist. I would argue Facebook's not a proper listing, but they might get away with that. But as long as there's no evidence to the outside world that it's been listed for sale, generally the court will allow it to proceed. If the property hasn't changed hands in 6 months, that is another bar you have to clear. If there's legal construction that has taken place in the last year, generally the court will not intervene until the property, unless the property is a severe problem. It's made exceptions in the past. And lastly, the property can't be in foreclosure. Now, foreclosure is narrowly defined as a bank foreclosing on its loan. The city foreclosing on a tax lien through their process is excluded from that. They argue that it's not, but the court has found against them every time that I'm aware of. So it just relates to, Deutsche Bank coming in, filing a foreclosure action, and getting a judgment. It also includes the period between them getting a judgment and taking it to sheriff's sale, if it hasn't been like 10 years. So those are the main things that would bar someone from filing a conservatorship action. Basically, to begin the court process, you got to identify the property, obviously. Sometimes it's not as easy as it seems. There may be several properties on one deed, or one property or one dwelling may have been built upon multiple lots, and you have to figure out if the person did it legally, if it was owned. Otherwise, there's other processes that come into play. Once you have the property identified, you have to pull a title report, figure out what the liens are, so we can present those to the court. And you prepare the filing with other things like telling the court what you're going to do for the property to make it non-blighted. Then you file, you notify the owners and any lien holders.
No.
Oh my God, they put it there too.
No, you don't.
That one's on my coffee.
Why is it in coffee?
If we can ask everyone who's not Rick to mute yourselves, it'll be easier for everybody to hear. Thank you.
It's okay. I just checked off a square Zoom bingo. So you file the petition. The court issues generally an order. It's been slower coming in these COVID times, but hope springs eternal. You post the order and a notice of the filing on the property, and you track down the owners, track down any people who have liens against the property, and let them know. So once you go to court, you have to prove several things to show that it's blighted. There are 9 factors that we can get into in a minute, but basically you have to prove 3 of 9 factors, which include things like open to people getting in or being sealed up, like the property on Girard Avenue. There's a major structural failing to a component, like the roof on Girard Avenue and several other portions of it. If it's public nuisance, it's causing damage to neighboring properties. Mark has to go out and clean in front of it, all the time, I'm sure. If kids play in it, if it's open, If it's become a magnet for at least illicit activities such as drug use, graffiti, we see on a lot of them. One of them, a squatter was running sex workers out of the property, and we kicked him out of that property and we're starting one down the street. And the owner's defense was, well, you sent the squatter there because you kicked him out of the other property that you were rehabbing. So these things have a lot of interesting turns, but if the property has a squatter in it, no matter if you were responsible for them to losing their last squatting area, that counts towards the court. There are a couple other factors we can get into later, but once the court is satisfied that the property meets the criteria, one of three basic things can happen. The court says, conservator, I like your plan. I think you got, financial backing. Go forward and repair this property. That often happens in times when no one shows up for the other side, which is probably 25% of the time. Another option of what the court can do is say, okay, this property is in terrible condition. You haven't done anything with it. You've come in, you've told the court that, hey, I've had all these plans for all these years. I've started on it. Usually after you file the petition, all of a sudden they start calling contractors. Or the owner can sell the property under the court's supervision. The thing that is important about the three different processes that can happen is in 2014, the act was amended so that if you file this and an owner says, I'm going to do the work, and the court lets him do the work, or you file it and the owner just sells the property, which was happening quite a bit, the person who files or the entity that files is not left holding the bag. The legislature built in recovery of 20% of the price of sale, or 20% of what someone puts into the building to fix it. We can get in a little more detail if people have questions over that. If a conservator is appointed, the conservator comes back to court and says, after they've entered the property, says, hey, this is what we think we can do with the property. We've had our contractor out there, sometimes engineers, plumbers, and this is what they say we can do. The court either approves that or says, hey, come back and give me another option. Sometimes, very rarely, we get into these properties and, they're not salvageable. And it just has to be demolished and sold as vacant land. So once the court says, conservator, I like what you're going to do. This is your final plan. Go forward. The conservator goes to work. And once the conservator is finished with the work, we go back to court and we say, court, we're done. Can we sell the property? And the court generally agrees as long as the owner doesn't show up and say, I'm going to pay all your expenses plus the 20% that you should get as a conservator. Once the court approves selling the property is sold free of liens, and you wind things up with the court, just telling them where the money went, and if there's anything left. After the sale of the property, it goes to the owner, or in the case of the Temple Brotherhood, it would be a like charity. So the end of this process, I suspect, with the location and size of the lot, there should be funds left over that will go to some other charity that is actually performing the work of the mission, which with a lot of these nonprofits, it's been a shot in the arm. There's been one that Mr. Palmer and I did that a charity received close to $1 million, I think, in excess proceeds. So, it can be good for all involved, and it can really help the community, in addition to removing the one actual property that is the problem. So when you do go to sell the property, there's a few things that get paid out of it. Obviously, municipal liens. the city gets the money that they're owed, that the owner probably has been paying them for a while, and license and inspection violations that have racked up, plus stream of revenue from new taxes and the transfer taxes. So it's a pretty good deal for the city, whether they realize it or not. Then the conservator gets paid out, and like I said, the rest goes to whoever's left over. Joe mentioned the VFW post. This is one of the first filings in Philadelphia. This is what it looked like before. That's just one end of it, and that's what it became. So it really cleaned up that part of the block, and you know, down the street, down 8th Street from there, there's been quite a bit of development. I wouldn't say it's necessarily because of this, but it definitely helped. And that was 2011. So we all know what's happened in Bella Vista and the area between there and Washington Avenue in the last 10 years. So that's a basic overview. As we have questions, I have other slides with more detail, but Mark, I don't know if you want to.
Well, one of the things I think would be important for everybody on this meeting to see is, because as we go through it, and I know certainly, you know, when I was, you know, I still do it, I have a pad and paper in my glove compartment, and whenever I drive through the neighborhood, it's like art, you know, when you see it, you to know what you're looking for when you're identifying properties. If you could pull up, I know you have the slide, Rick, with the specific criteria of the, there we go. And kind of lead everybody through that, that would be great.
Okay, so as I mentioned, when you go to court, you have to prove your case. Thankfully, the legislature spelled out some areas where we can prove our case and gave us kind of a catch-all, which is that the building is a physical nuisance. The building or the structure is a public nuisance. That has a legal definition, but it's like Mark said, you know, when you see it. If the building is needed substantial rehabilitation, so if the roof is failing, usually the front of the property remains intact because they're built fairly well, but you know, the missing windows, and you can see that it's rotting from the inside. A lot of them on the rear of the property is, you know, where it's falling down. You know, the bump outs that everyone put in the 50s that are sitting on dirt and stringers tend to collapse once they've been abandoned fairly quickly. If whether the property has been is fit for habitation. This is a standard that the court kind of interprets for itself. It doesn't necessarily mean it has working water or electric, as we've found. But, you know, if someone's illegally hooked up to the water supply or the electric supply, that can be evidence of it not truly being habitable. The building, the condition or the vacancy increases fire risk. Some of these have squatters, obviously, that start fires. Some of them have had fires that have gone through them already, and that's why we're getting called, is they've been abandoned and it's caught fire. We've had several of those. But you know, just saying, hey, it's a vacant property, it's more likely to catch on fire. We haven't had much luck with that, but you know, that could change as the judges that hear these cases see more of them. We talked about unauthorized entry, squatters. This also includes if L&I has had to come and board the property, and you'll know it because there's a big yellow no or orange no trespassing sticker on the property, and below it there's a little L&I tag. We actually had someone come to court saying that their property was secured because L&I was doing it, and her proof was the no trespassing sign that L&I puts up. And that might have been one of my favorite days in court. But you'd be surprised the defenses some people come up with. The same person claimed that they were maintaining their property because the city was cutting the grass, but so the other one of the other factors is if it's an attractive nuisance to children. Generally, anything near a school or a park that has debris in the rear is open, and unfortunately, if you don't have a photograph of a kid playing on it, a lot of times the court will discount what the neighbors will tell the court about, their fears for children. But, if the next door neighbors say, hey, the kids get out of school, they climb over the back wall every day and hang out in the backyard and in the property, that's a different story. And that goes a long way towards proving a conservatorship. The appearance of the property negatively affects the economic well-being. This is more of an issue on developed residential blocks and commercial corridors. We like to say that, you bring one of these properties back and the rest will follow, which we've seen has been a trend, especially in the commercial corridors. And that generally requires us to bring someone in to talk about the economics of it. And finally, as we talked about briefly, if it's attractive to illicit purposes like graffiti, prostitution, drugs, anything else that you can think of that's illegal and people are hanging out there doing. But that's basically what you would look for in one of these properties, as far as whether it meets the criteria. And if there's something else really wrong with the property, generally we try and argue that it's a nuisance and fit it in that way.
Rick, when we did the revision, wrote the amendments back in 2014, vacant lots became an issue. Could you talk a little bit about what we look for a vacant lot to be applicable for this act?
Sure. So for a vacant lot to be subject to the act, it has to have once had a dwelling on it. Normally, if a property's been demolished, they'll go in and backfill, but they don't take out the foundation. So on a lot of these lots, you can see the foundation poking up, or you can see the bricks from the previous building are left there. Usually lots are a little bit more difficult to prove your case on because you don't have a dwelling to prove a lot of your factors, but they are generally more inviting to kids. They are generally more of a magnet for short dumping and people just throwing all of their stuff on. We had one case, it was, my client had the vacant lot, and the person who was doing their own rehabilitation dumped all of the stuff from the inside of his house onto my client's lot. We had to go to court and say, hey, here's pictures of what we showed you the first time around. This is what the guy's throwing on now. But, we have probably 100 stories about it. But anyway, as far as lots go, you have to have had a dwelling on it previously, and we have to be able to show that either through city records or photographs showing, a partial demolition or evidence that the property was demolished at some point.
One or two more things from me, then I'm going to go through some of the questions that are popping up. When the act was, you want to go through that? This is the court finds at least 3 of the following, or did you already do that? You already did that.
Yeah, we did.
It used to be one petition, one court, one pleading, one property. How has that changed since the amendment?
Now, a property that has an interrelated function can be filed on, much like the Brotherhood Temple of Psychiatric. I forget the full name of the property in Girard Avenue, but that is actually 3 lots with one, from what we can tell, one building on it. It looks like it might be one building, and then they kind of added on part of a building to it. But So in the past, you would have to file 3 separate petitions and, say, hey, look, it's the same thing. Now you can file one petition, which obviously saves time and cost. Also, as it relates to side lots, if the property is owned by the same person, so, Mark owns a dilapidated house and there's a lot next to it, you can file on both of those because they're interrelated, and we can show that all the stuff that Mark dumped out on the lot 5 years ago is now evidence of the blighting effect of the building.
And just to be clear, I do not have a blighted property, so that was for example purposes only. Rick, if you could pull up the slide, one of the things that we also brought into the amendment was the fees. That one, if you could go through that a little bit more, because what we were finding was we were filing on these properties, and as Rick was saying, all of a sudden they're selling them, they're going to fix them up. So for the neighborhood, the benefit is there because the property is repaired and the blight is remediated. But we've now had to go through the step and the costs of filing litigation that really was the reason that prompted the change. So we wanted to ensure that the conservators were protected and indeed incentivized to do this. So Rick, if you could run through that fairly quickly.
Sure. So like Mark said, before 2014, you could file one of these and come away with the relief you were seeking, but you were out of pocket a significant amount of money. So we added a incentive, which the legislature found to be a good idea and actually put it as part of the rationale, that the person who petitions and or the conservator will be guaranteed, as long as you can prove that it's blighted, at least it's up to about $3,000 now, but usually it is 20% of whatever the property sells for, whether the conservator takes over the property and does the repairs themselves, or the owner decides to sell the property. The other possibility is if the owner decides to repair the property themselves, the conservator is entitled to a 20% markup of the cost. So if the person spends $100,000 fixing up the property, that'd be $20,000 on top of that due to the conservator for their time and efforts. When I say conservator, I'm also mean the petitioner, if they are different entities. So that is what was built in to try and not only make an incentive, but to keep it from being negative cost to a person who's trying to help their community.
Thanks, Rick. One question that just came up, and this is an easy one. Does the proposed conservator need to provide a development plan and demonstrate the financial capacity for capital improvement? Yes.
Yes. Yeah, part of the petition is your initial plan of what you intend to do with the property if the court awards it. So you come up with generally a narrative of, I think that we could develop this property to a clean envelope, is what I call it. Basically, you clear the blighting influence in the exterior of the property. Usually that means doors and windows, sometimes pointing or painting, and then on the rear, whatever's wrong with the rear of the structure, fix that, seal the roof, make sure the joints and the rest of the interior are solid, and then sell it to someone who's going to agree to further develop the property. That limits the cost of the person who is acting as the conservator, and allows a conservator to do multiple projects in a more efficient manner. You of course have the ability to present a plan to the court that includes a full rehab. You can present a plan that says this property, there's no way to save it. We have to take it down to the the land and demolish it. So that's what initially you would present to the court, and that can change because you go back to court about 120 days after you're appointed, had a chance to go through the property, go through it with your experts, your engineers, your contractors, and architects sometimes, and you're able to put a more formal plan to the court that says, this is what we intend to do. The court approves it or says, I want more. And your plan normally includes the financing, especially the final plan. But as a general rule, the court will look to the conservator to make sure that they have the financial wherewithal to complete the project. So that is a threshold question, but it's not as formal as one would think. You don't have to have a mortgage lined up if you have a letter of credit, or if you have, enough money in your bank account to cover at least starting it. Generally, the court will take it on a case-by-case basis. So you don't have to be, Toll Brothers to do this.
Rick, one of the questions I know what people ask all the time is, how long does the process take? And I know it's when court's involved, it's hard to put a time frame, but what are some key time dates that people need to look for in filing?
Well, I will say this with the pre-COVID caveat, because everything has slowed down quite a bit. But under the Act, you're supposed to get a hearing on whether or not you should be appointed conservator within 2 months, 60 days. Sometimes that gets pushed back when you have difficulty finding an owner. A lot of times an owner will come to court and, ask for more time, but it's supposed to be heard within 60 days. Then in another 120 days, you go back to the court and you say, this is our final plan. This is what we're going to do to fix the property. And Shirley Turco generally turns it around within a few months to do the work. And then you finally go back to the court, generally within 6 or 9 months to sell the property, to recoup your costs, the conservator's fee. And that's where the owner has the opportunity to step in and say, hey, I'm going to pay you everything. Thanks for doing this. And the court says, okay, pay the people and you can, take over possession of your property. As I think Mark stated quite clearly, we don't take title to the property as conservator, but you have every other right that an owner would have, including applying for permits, applying for grants, applying for an estate. Sometimes it becomes an issue. You have to do a transfer tax workup so that the title company's happy. But yeah, so that's kind of a short of it.
Thanks, Rick. And one of the wonderful things about this act, and obviously I'm passionate about it for a lot of reasons, as are Rick, Beth, and Joel, is this is probably the fairest process you're going to see, because everything that is done from start to finish, including the out sale, has to be approved by the court. Everything has to be on the record, from every dollar that you've spent to every dollar that you're going to charge. We cannot undersell a property. It has to be fair market value. So when we go, or at least the ones that I'm involved in with Shirley Turco and with Rick, we go into court with neighborhood witnesses, whether it's residents who have to deal with the blight and deal with the problems that it causes, or commercial property ones, same thing, neighbors that deal with the issues that this problem has caused and the effect that it's had on their properties. I always come because I talk about the role that I play here, both as the corridor manager, but also I have the luck of being able to talk about legislative intent, if we have to be able to do that. And we've actually had to do that on several occasions, right, Rick, regarding like public nuisance and definitions and things like that.
And early on with the conservator's fee.
Yes.
It's an issue.
And we will, if need be, we will have someone from the local police district there and a police officer in case there's issues of crime. We've subpoenaed the L&I inspector to get all of the violations and the problems put on the record. We leave nothing to chance. And we also bring in, we will always use a local realtor who will serve the purpose of a couple things. First off, that realtor can give the negative effect that it's had on property value, both to this and to the surrounding neighborhood properties, and also what the fair market value of the property would be regarding selling it. So it's a very thorough type of procedure. And again, it's because we're making sure all of this is on the record. We want to make sure that we not only win in court, but survive the appeal, because our goal is to help. Our goal isn't just to take a property. I'm always reminded of this story, which is one of our nightmares in Bridesburg, where it was a nice old property. It had been damaged by a fire. The woman who owned it was elderly, and she would often sneak back into the burnt out property at night to sleep. Sadly, she was in the throes of dementia. Well, luckily, and this is why I love working with Joel and Rick and Beth, is they weren't there just to get control of the property to fix it up. They were there to help this woman find a place to live, find people that could help her. The nightmare came that once we became conservator, I think it caught on fire 2 separate times after that. But we got it done. So there's always a war story. There's always something to it. But I think it's important to know what we could do. But I want to open it up for questions. Here's one. I'm just going to the chat now. In this particular property, and if you don't know, Rick, we could say so, was there any deed restrictions to 401-05?
I honestly don't remember. I think if there were.
I don't believe there is.
Yeah. There is an overall restriction with nonprofits that any funds that come from the sale of the nonprofit go to a similar nonprofit. So ideally, at the end of this process, there will be another mission that receives, or several that receive the proceeds of the sale.
And the second part of the question was, has anyone spoken to OHS yet? Not yet. We certainly would once because the first step is making sure we're appointed conservator, and then we'll make sure to address those things moving forward. At this point, we have some minutes left. I want to open it up for questions, whether you want to put it in the chat or raise your hand and we'll unmute you.
While you're waiting, Mark, just wanted to add one thing on the properties that are charitable trusts. We've worked successfully with the Attorney General's office, an attorney named Pam Fingerhut, on making sure that those funds that are left over go to either another charity or a designee of the Attorney General's approved choice.
Thank you, Joel. And that is a requirement we always follow whenever these situations exist, because the Attorney General's office always has not just a charitable trust, but even if there's a decedent, in ensuring that heirs or certain charities receive, their funds are protected. So thank you for that, Joel.
We do have one question from Venice with her hand raised, so I'm going to go ahead and let Venice unmute.
Thank you. Go ahead, Venice.
Hello, good afternoon. Can you hear me?
We can hear you great.
Okay, just I have my mask on and a mic. So a couple years back, when this property had first got shut down by L&I, they had approached Council President Darrell Clark to help with assistant funding and any other resources. At that point, we had spoken with Liz Hirsch and OHS about it. We did a thorough, I would have to get my files from my office, which we're all working virtual, but we did a thorough case on this. I believe I do have the contact information. I know it was a new leadership in the Brotherhood mission with it. That's why I'm just wondering if anyone has checked in with them, because I know they were looking for funding aspects. I know it's been a blighted property. I actually received complaints about it, but just want to make sure that the owners are aware of this happening.
Well, I think from at least our studies and our searches is, I think that the owners, because the mission is no longer in existence, and that who owns it. And I talked to Liz briefly about it when it first came on our radar, and she wasn't aware of any connections for several years. So when we file, Venice, just so you know, that ultimately the court can't proceed until we show them proper searches of owner or that the ownership, the charitable trust no longer exists. So that's the due diligence that we do, and that's all presented at court.
Like I said, I have a file on it in my office with all the
Great.
contact information and when I met with them. Just again, want to make sure that this Black Mission, owners, that they are aware of it. I know that there were religious organizations up in the Northeast that were also doing food banks with this mission right before they got closed down. So again, I know it's been some time in Blight. Just want to make sure with that. And I believe I did do a deed search. So the deed may be in trust to as a mission or food bank. Maybe something you want to just pull the historic deeds and just look into that. But I believe that it is in trust in some ways. All right. Well, thank you very much.
Thanks, Venice.
Thank you.
Appreciate it. And listen,
I would-
any information is always helpful, and we appreciate always working with Councilman Clark's office. Rick, here's a question for you that came up on the chat. Still not clear about the end part of the process. Can the property be designated to or sold to a new owner, or must it be sold to the public? Which I guess that means, could we come with a proposed owner too?
It really depends on the judge you get in front of, frankly. Some judges will sell it to whoever the conservator asks, as long as you can show them that you're getting value for the property. So, for example, the current judge likes 3 appraisals or 3 appraisal-like. So you do 1 appraisal and get a couple of realtors to give you a comparative market analysis or a broker price opinion, and use that as to pin your value to. So if there is an entity that you're looking to designate a sale to, it's possible, but can't be guaranteed, and it would have a lot more likelihood of success if that was an entity such as another nonprofit or affordable housing, that type of thing, that has either you're getting resources because you're using a grant to do the rehab, or you're trying to keep it in the similar use in the community. So the statute does give some leeway as to who ultimately ends up with the property. Typically, it is listed on the MLS or LoopNet for a broker supervised sale that is then presented to the court. However, there have been instances where we've identified a buyer and given the court, comparative analysis of what the market is, and, asked the court to approve the sale based upon that amount.
Thank you, Rick. And just so you know, with this particular property, both Rick and myself had a long conversation about this and other properties with Revenue and the Law Department, and also I actually briefly talked to new L&I Commissioner Ralph DiPietro. Ralph's a good guy, very good at his job. We'll miss certainly Commissioner Perry. Wish him well. We'll miss him. And Ralph was certainly thrilled to know, because since I've been here, it's at least 6 or 7 times that I've had to contact them just to try to make this place somewhat safe. So he was thrilled to know that we filed on it as well. Before we go, are there any other questions that any of you may have? Please note that we will be making sure to share the video, the recording of this, on our social media pages, which is the Fishtown District. Our website is fishtowndistrict.com. And we'll also have it with this PowerPoint in our newsletter as well, in case for those that didn't see it. But any further questions before we wrap it up? Hearing none, and we're right on an hour. I want to, Beth and Joel, do you have anything you want to close with?
I just would like to add, Mark, thank you all very much for this this seminar and for all the folks who signed on and attended. My great compliments to Mark and to Representative Taylor for authoring this law, and for Rick, who is one of the subject matter experts in the Philadelphia bar and is recognized as such. And without these two gentlemen, none of this would have been possible.
Didn't
And
I
I
tell
just-
you he was the nicest guy you're ever going to meet?
Yes. And
Thank
I
you.
just, yeah, and I just thank all of you. And please know we are here as a resource. Anything we could do if it fits our criteria, I'm certainly game for it. And please feel free, whether through Mark or Rick or myself or Joe, to refer any properties to us. It doesn't have to be within the bid. It could just be something you're driving by and you see and you're curious, that's always been sitting there for years. We certainly welcome all referrals. And thank you all.
And actually, one last thing I want to do, because this is always a partnership. We always used to joke when we would do these seminars for the however many years we've been doing them. It was like, Gladys Knight and the Pips. We should have had this down. I want to thank Shirley Turco because we also filed this year with the Commonwealth of Pennsylvania a blight remediation grant, where we formulated a plan of how to identify, secure, and move these properties back into productive use. We're hoping, and as the calendar changes to 2021, and hopefully some normalcy comes, that all of these grants that we've filed that are pending will finally get heard and awarded. But we also thank Beth, Joel, and Rick for their hard work on that as well. And we spent many a meeting in Fishtown touring, going back and forth. So thank you. Rick, anything you want to close with?
No, just thank you everybody for showing up today. I can be a little long-winded. I apologize for that, and a little rusty in this presentation too. So thanks for bearing with me.
Guys, thank you so much. And we'll keep everybody posted on our progress, and have a great day.
Thank you.